All right, I'm with Joe Dodson of Courthouse News Service. He was in the Lancaster courtroom today when the judge issued an injunction against the assault weapons legislation that would have banned assault weapon purchases in the Commonwealth of Virginia. I kind of butchered that, but you all get the point. Joe, thanks for talking to me. Let's dig right into this. So you were in the room. Tell us what happened.
Yeah, so thanks for having me, Brandon. Yeah, I was in the room. It's like a hour and a half drive from Richmond to Lancaster County, which is in the northern neck. And yeah, it took about 2 hours. Both sides had two chances to talk. The judge took like a 10-minute recess in between, and then he ruled from the bench. So we don't have a written order as of yet. But we do know the outcome, which is that he is going to grant the preliminary injunction just 6 days before this law would have gone into effect.
So this injunction, it's just on the Virginia State Police. It doesn't specify localities. Do you have any idea what that means and why it's just the police?
It's a statewide injunction. The Virginia State Police are tasked with doing background checks. They're tasked with a lot of the things that go into the process of purchasing a weapon or transferring it. So I think that it is, although it's technically the injunction is against Colonel Jeffrey Katz, which is the superintendent of the Virginia State Police, I think it has pretty far reaching consequences.
Yeah, so I mean, people can keep buying their assault weapons after July 1st now. The law was supposed to stop it. And there's several more lawsuits that are attempting to do the same thing. I talked
Yeah.
to Senator Bill Stanley today. He was in, what was it, Washington County,
Mhm.
and he said that his hearing went really well. And he actually asked the judge to make this ruling for the entire Commonwealth, not just state police. But as he pointed out to me, the judge can do whatever he wants. He can do caveats, he can do whatever, but he's expecting to hear from that in the next couple of days. So let's talk about the deliberation. How long did it take the judge to come to this decision? What happened in the courtroom? Give us your perspective.
So this was kind of interesting. The judge had a written out kind of order ready to go that like very obviously he didn't like just come up with. I think that I know he had spent the week going through the briefings, lots of briefings, especially from the Commonwealth. And I think that he had kind of already come to some sort of conclusion. And today's hearing was just to, it didn't end up changing his mind on anything because he ended up just reading out this pretty long um, kind of written statement breaking down exactly what his ruling was. One interesting part of it that is of note is that he found that the organizational plaintiffs, so Owners of America and the Virginia Citizens Defense League, lacked standing to sue on a for represent representative purposes. But they did allow the lawsuit to go forward with John Crump, who's the individual plaintiff. And in Virginia, there's case law that says as long as there's one of the plaintiffs does have standing, the case itself can proceed.
What does that mean, standing?
So standing is just like it's a threshold question you have to get to before you can even get to the merits of a case. It's the judge has to basically decide whether or not he has jurisdiction to hear from whoever the plaintiff is. So to establish standing, you have to show that that you're suffering a harm, an injury, so to speak. And he found that John Crump individually would suffer a injury should this law go into effect because he submitted an affidavit where he kind of detailed the firearms and the firearm parts that he wanted to purchase and that he would not be able to purchase if this law had passed, or I should say, if this law had gone into effect.
So this was just a preliminary hearing or whatever. He issued the injunction while the hearing's taking place. I think it's fair to say this is a sign, not a good sign for the Democrats that the law will eventually go into effect. But what does this actually mean for the hearing moving forward? I mean, I know you can't read too much into it, but I mean, what does an injunction placed at this point typically mean in a case?
Well, it is interesting with how close we are to July 1st, um, because I do think that, like, irregardless of the Commonwealth is obviously going to appeal this ruling to the state Supreme Court, who's going to have the final say on this issue. Um, and what's interesting, though, is just kind of the proximity to July 1st that the odds of the Supreme Court of Virginia being able to take this up in the next 6 days are pretty low. I think the Supreme Court of Virginia is waiting to see how all of the individual state cases across the Commonwealth. So there's the one in Washington County, but there's also one in Fauquier County. There's also one in Spotsylvania that's been appealed, that's likely going to get appealed. I think they're waiting to see how all the individual state courts rule on it, and then they're going to consolidate for the purposes of saying whether or not it runs afoul of the state constitution.
Yeah, so as we both reported on before, there is a panel of put together by the Supreme Court to decide if they want to consolidate all these cases. That panel hasn't met yet. I talked to someone, I think they meet on July 3rd, and that's where they'll decide if they want to consolidate all of these cases challenging this law. And it's a panel of circuit court judges put together by the Supreme Court. But I guess at the end of the day, this is going to end up in the Virginia Supreme Court and possibly the United States Supreme Court, right?
Yeah, I mean, I don't know so much about the United States Supreme Court. For those who follow federal law, the United States Supreme Court has yet to take up assault weapons ban or a high capacity semi-automatic rifle ban, however you want to say it. They've had multiple opportunities, including our neighbors in Maryland, who they had a case that went to the Fourth Circuit challenging their assault weapons ban, which the Fourth Circuit narrowly upheld. The Supreme Court decided not to, hear that. So I don't really know why they would hear ours more than other states that have already gotten to the point where it's, at that level. But definitely should expect to be in the Supreme Court of Virginia at some point for sure.
And then that brings me to really my last question. When the judge was deliberating this, did it seem like he was taking more of a look at the precedents from the United States Supreme Court or like, other stuff?
Yeah. So one interesting thing about this case was that the Commonwealth, in particular, didn't want the court to rely too heavily on the Supreme Court's analysis, the United States Supreme Court's analysis rule from New York State Association of Pistol Owners versus Bruin, which is a incredibly important Second Amendment case. And just this morning, a lot of it was reaffirmed in a case concerning Hawaii's vampire permit rule, which that was really interesting. So, like a very monumental Second Amendment case was decided this morning at the Supreme Court, and the lawyers in this case had to kind of very quickly react and like see how does that ruling fit with what we're arguing here today. Ultimately, the Commonwealth asked for some more time to do supplemental briefing if they're going to talk at all about the case from today. But the judge ultimately relied on a Virginia case that I believe involved some sort of firearm regulation with George Mason University. And in that case, the judge had said that the article, the part of the Virginia state constitution adopted or enacted in 1971 that has a enshrined right to bear and keep arms is coextensive with the Second Amendment. So that basically just means if it's pretty similar to the Second Amendment, we might as well use the same type of test. And under Bruin, that is a two-part test. The first part of that test is whether or not the challenged regulation is protected by the Second Amendment. So the Commonwealth had a little bit of argument about whether or not the weapons that are a part of this particular law constitute arms, like bearable arms, and what that means. So they talked a lot about like military weapons in particular, and basically saying at that first step of Bruin, um, these aren't the arms that are protected by the Second Amendment, so it fails there. They were not successful in that, so they moved on to the second step of Bruin, which seeks a historical analog to a traditional firearm regulation to kind of show that this is something that's been around for a while. And so the Commonwealth pointed to um, they pointed to laws like 1968, Virginia banned sawed-off shotguns, and in the early 30s, we banned machine guns, and in a way long time ago, we banned like Bowie knives and like trip guns, like the type that kind of used for hunting. So they kind of pointed to that stuff as examples of the state having like a past of regulating certain arms. But the plaintiffs in this case countered that like a lot of those laws were created on for concerns with hunting. And also the two main ones that they cite, the one that regards sawed-off shotguns and the machine guns, like those were passed in the 20th century, which isn't exactly a long-standing historical tradition that they can fall back on. I've covered a lot of Second Amendment cases, and a lot of them they're looking for something from the founding era that connects to a modern day law, but this was more looking at laws from the 20th century, and kind of tying those in. So he ended up uh, finding that Bruin was instructive, and because of that, he ultimately sided with the plaintiffs.
All right. Well, I guess we're going to see where this goes, and I'm sure we'll be talking again as it makes its way through the court system. Again, this was Joe Dodson from Courthouse News Service. He was in the room today doing his thing, and go find him on the internet and read his work. And again, thanks for talking to me today, man.
Yeah, thanks a lot. See you, Brandon.